So that was our first time taking part, and we won.
Evergreen! Evergreen! We move regardless.
Thank you so much, Mr. Wellrich. Let's put our hands together for him one more time. Very shortly, we will be wrapping up. I know I've said that many times, but I'm honest, we'll be wrapping up very shortly. I know that certain, savories have come round, but it's now time to have the actual dinner. It's not too late to eat, is it? You can have something very light. And so, ladies and gentlemen, help me welcome on stage Purple Strings to give us some good music as we have dinner, and then we can wrap up, because we don't want to send you back home hungry. We want to feed you and feed you very well. And so, table by table, you will make your way to the different sets of buffet available and eat any and everything available. Purple Strings, please take us away.
Bank of Africa, as strong as a group, as close as a partner.
Where Duraplas goes, water flows.
PS Industries has introduced a new roofing system known as ColorLink Plus.
Flamingo paint, simply superior. Syntex tank, are you strong? Are you tough?
Cherry Tree Properties. We develop spaces as though we were going to occupy them.
The Chief Justice of the Republic of Ghana, head of the third arm of government, the judiciary. Her Ladyship, Justice Araba Isaba Saki Tokono, has been suspended from office on the advice of the Council of States upon the determination of a prima facie on 3 petitions, and now we are learning 2 extra petitions brought to the President for her impeachment or removal. A committee has been set up pursuant to the Constitution for an investigation to begin. The NPP, as a party and the minority in Parliament, have labeled the process as farcical. They say it is an unconstitutional process that is going on. They are asking the President to stop it, failing which they are going on a demonstration to get the President to stop the process. FIDA, you may not have heard about them for a long time. They've issued a statement condemning what is going on. We've heard from the Ghana Bar Association, taking what people have called a measured approach and urging all of us to follow. They're asking the committee, the President, the Council of State to ensure that due process is followed. The MPP says this is nothing short of a brazen judicial coup, a reckless abuse of executive power, and a direct assault on the independence of Ghana's judiciary. Their exact words. So, is what is happening unusual? That's the question we're asking. Can it be stopped? Should it be stopped? The minister who has been giving the mandate to help us to stop the existential threat of Galamsey held a press conference and he wept, he shed tears. What was all that about? We'll be right back to deal with the vexed matters. I'm Samson Ladi Anyanini. Welcome back. This is Newsfile. It's your most authoritative news analysis platform. And when we say it's your most authoritative, we mean exactly that, because we know what we do here. Now, let me get quick and fast with something stake. And I'm just, once again, asking just a few questions. But let me begin with Article 21 of the 1992 Constitution. Article 21 of the 1992 Constitution is found in Chapter 5. Chapter 5 is what you call the Bill of Rights. And this is where we have our fundamental human rights, guaranteed, not given. They are guaranteed because the nation or the state doesn't give those rights. Those rights, we call them in law inalienable rights. They are part of us because we are human beings. We are born with them. The right to life, we are born with it. Nobody gives us the right to life. So governments don't give us that right. They only sort of guarantee it. And so if you read in Article Chapter 5, Article 12 to start with, it says the fundamental human rights and freedoms enshrined in this chapter shall be respected and upheld by the executive, the legislature, and the judiciary, and all other organs of government and its agencies, and where applicable to them by all natural and legal persons in Ghana, and shall be enforceable by the courts as provided for in this Constitution. They are to be upheld by the executive, the legislature, and the judiciary. The executive has over a period abused this particular right in Article 21, which it is supposed to uphold. Article 21D says all persons shall have the right to freedom of assembly, including freedom to take part in processions and demonstrations. The executive has sought very deliberately to curtail this right. And guess what? They have been ably assisted by the judiciary. Yes, our judges. Let me tell you guys something. And when I say you guys, I mean those of you who look at me and say, oh, what is he talking about now? Where was he yesterday? Me, yesterday. Just Google demonstrations and put my name there. And you see that at every time I have been against the police for how they have mutilated this right. At every time I have been against the courts for how they have mutilated this right by paying a certain reverence to the executive when they don't have to. And sometimes when I do these things, some judges have been caught flat-footed, completely wrong, giving decisions that are completely incompetent, that should lead to their removal from office. And when I sit here, and sometimes I ask just questions, some of these judges take it personal. I'm a practitioner. I'm in court almost every day. So I meet them. Some of them take it personal, and they take it up against me. When they do it, they think they are acting against me, but they're acting against my client, who is innocent. But I will continue to do it for as long as I live and want to do this. Now, this is a subject I have spoken about, and I've gotten to a point where I'm tired. I was literally giving up. Again, I don't understand when some people do certain things at a point, and then sometimes they get weary, they get tired, they want to, hang their boots. And we go at them and say, you were talking in the last administration, you should talk in the next administration. But you two talk some. Why? Have you sort of designated them to be the ones who should be speaking in the public about everything? So the executive has been enabled by the judiciary sometimes in a very bad and poor manner. So shambolic, and they do it. So I say, the fact that the Attorney General, Dominic Ayine, and his team decided that the police's decision to try to stop and curtail this demonstration was wrong. And they went to the court and told the court that we want the police to withdraw their application, or even if it's their own application, so to affidavit in opposition, they want to withdraw it and ask the court to strike out the motion to, as it were, seek to stop these people. It's a very good thing. It is very refreshing. We can only say thank you for not seeking to do this. Look, Ghana Police, the Jubilee House, you see, in the same way in the occupied Jilobi House, you were able to cordon off a particular point and allow them to do the demonstration, which you sought to stop. You can do the same today. If the Attorney General had not told the court that they were not interested in pursuing this, the judge would have granted this. I can almost guarantee that the judge would have said, don't go and do it here, don't do it this way, don't do it that way. Why are you always beholden to the executive? These judges who do that, you have a responsibility under the Constitution to uphold these provisions. The executive, once you're appointed as a judge, you should not be beholden to anybody. So our judges, you can help us. And this is a good start. If the Attorney General or the police next time come to stop a demonstration, don't take the same reason they have been giving since when? Every day they repeat the same reason and you give them an injunction. They used to do it ex parte. They'll go hide behind the people. They won't know anything there. And then Justice Dennis Ejay came and struck that down. Then suddenly it surfaced again. When you criticize, they say, well, he was only sitting in one high court. Another high court judge can think differently. Really? And the Attorney General was supporting this. The NPP was very much in support of this. What a shame. What kind of democracy do you want for us? Thank you, Attorney General. And thank you, this judge. Of course, once they withdrew it, you had no option. You had to strike it out as withdrawn. But this is the way to go. And this has been my take. I'll be right back. This platform, and here on Newsfile, we put Ghana first. And my guests are seated. And one joining us via Zoom, my very good friend and mate, Diana Sonabadapa, former Deputy Attorney General and Minister for Justice. Professor Ajimandua, Bafo Ajimandua, is former UN Senior Governance Advisor right here in the studio. Prof, thanks for making time to come here. We haven't seen you on the platform in a little while. Right. Inusa Hussaini, MP, Tamale Central, former MP, Tamale Central, and former ranking, Constitutional Legal Affairs, Parliamentary Affairs, is it? Committee of Parliament. He was Minister, different portfolios. Somebody said on my post when I posted the flyer that you are becoming a regular on the show. We are happy if we could have you. If we could have you every show. Right. Oliver Baka-Vomowo is Constitutional Rights and Policy Strategy Advisor at the Democracy Hub. It's been a while.
It's been a minute.
Always excited to have you on the show.
Appreciate it.
Right. So that will be for the very first segment, and in the second segment we shall have Kojo Akoto Boateng, a journalist with multimedia. He's a farmer. Also join us to look at the matter of the Galamsey. Of course, we are beginning with the suspension of the CJ and the processes going forward, but I appreciate that the subject of my take is of interest, particularly to Oliver, the serial demonstrator who has had to be picked up almost any time he says we want to have a demonstration. How does it sound to you, what we are learning?
You know, first of all, I must say that since the Attorney General and his deputy came into office, they've been in the news for almost the right reasons on a number of occasions.
Of course, with some wrong reasons also, but you focus on yours.
But I think I think for me it's refreshing. It's bizarre that, you know, after how many years of independence and how many years of operating the 1992 Constitution, the freedom of assembly has become the most contested right. But if there's going to be a direction, it must come from the highest levels. And I'm happy that the Attorney General, not only, because one of the things that we have been fighting for is not only the right to protest, but the right to assemble and petition the office of the president. The idea that you can be able to march up to the office of the president and petition is some of the things that we've been fighting for. They have considered to the constitutionality of this. And I hope that it sets the tone for the police and how we go forward on this. But even more critically, I think that in terms of reforms going forward, we have to remove that from the police and it should be vested in Attorney General. Because they must take ultimate responsibility over how we operationalize the freedom of assembly so that it not becomes a tussle between we and the police, that if the government is taking a position to oppose it, everybody knows where responsibility hangs. That they don't hide behind the office and the police feel that they cannot do this. So I must commend them, and I hope that, you know, it sets the limits of our rights as citizens.
You were planning a demonstration around the same time, and this is coming up. So what's going to happen?
So yes, we're planning a protest on 1st of May, and before an announcement was made to do a protest on, I think, on the 28th, 29th, 30th. And so we decided that, you know, one of the things that we have been fighting for is a broader culture of protest. So we don't want to take away the shine of other citizens who are joining the process of holding government accountable to a protest. So we are willing to support that rather than feel like we must lead every time. So we're going to, our intention is to provide legal support to those who are coming out to protest. We're going to provide critical essentials, water, drink, and also mobilize some of our volunteer nurses and marshals as well to help support the protest. So we believe in the voice of citizens anytime.
Great. Good to hear that. Good to hear that. Prof, brief comments, a minute or two?
I think basically he said it all. I mean, there should be no attempt.
So what the police used to do was that they used to go for an ex parte injunction, which means they'll go for, and you see how they used to do it. They'll go for the injunction a couple of days or on the eve of the event. Then the next morning, they spring a surprise on you. And so they say, you can't come to the demonstration because we have an injunction. And Justice Dennis Ajay gave a decision that they cannot go first to a lower court than a high court. And two, that's in 2015. And two, that it must always be on notice to the organizers and not a surprise.
Secret. Well, I think we need to codify these new developments to bring clarity to the matter so that the police cannot hide behind any clause in the law or whatever to do what they do. So I think basically we need to bring the issue more clarity so that both parties, the demonstrating citizens and the police and other agencies, will be clear about our responsibilities. Once we do that, I think we'll have a better way.
Great, but you're excited about this?
Oh yeah, very much so. Actually, when I heard the news yesterday, I thought this is progress. It's progress, you know, especially for the Attorney General to intercede on behalf of citizens to say, look, the police, you can't stop them. That we have to do. But the small part that...
Shouldn't they have told the police first, that first don't even attempt it? In fact, rather than wait, they file the process and then they go to court and then say,
let me jump in here, because in fact, I do understand that the Attorney General's office had been clear with the police not to do this. And then they still went ahead to do this. And in fact, they had asked them to issue a statement. Now, this is private information that I'm privy to, and that's why I'm hesitant a bit to put it out. But in fact, this is what their posture had been. And I know that the office was very displeased with the police for taking the step. Somebody described the police institution as the never-learning institution. Unfortunately, I have to agree on this.
Okay, so we just cut Prof. Yes, you were about to say something.
No. I said basically with him, there's a little bit of your earlier statement that I thought I should take a small issue with, where you said the rush should go all the way to the president's office and blah, blah, blah. I think somehow that small piece of land for the president, we should give it a certain respect. A president can decide to send someone to come and take your protest note, but to say that you want to go directly to the presidency to do that, I think it raises all kinds of security issues, and I don't think we have to put any president.
For you, it's okay around the Jubilee House, but not going in.
Not going to the president's office. I don't know if that's
no. We've never gone to the president's office.
What Dampari was doing was a standing order that demonstrations must not go close to the presidency. So he was always directing all of them to the Black Star Square.
You see, again, it depends on the security threats perceived by the security agencies. You know, even the White House, you don't go near the White House if you are protesting. They have bars. So I think there must be a limit to the extent to which you approach the president. That's all I'm saying.
All right.
But your right to do should not be breached at any part.
So the conversation is simply, which areas do we define as security zones that are off limits to strike?
For me, the Jubilee House, especially going through the gates.
That fits into what Oliver is saying. We must define that clearly.
Precisely.
It's a right that we have to enjoy. I have, since the days of President Kufuor, I have fought for this right. I think that Public Order Act was not intended to frustrate the enjoyment of that right, but to regulate it. And regulate it in such a way that you don't prevent people from expressing their views.
I hope you are not interpreting what you are taking it. I never said that.
The point that is being made is, should they have access into the presidency?
No.
Exactly.
Or how close?
So I agree entirely with
Is it reasonable to expect that the demonstrators will go into that place?
I agree with him. I'm just saying that it borders on regulation.
Okay.
It borders on us building consensus on areas that we ought not to go, so that we can enforce the restrictions on those areas. Now, but that right should be expanded, and that's why we are commending the Attorney General's office. It's extending the frontiers for the enjoyment of that right, and citizens' actions against policy or against acts of impunity by government is always important in a democracy.
Absolutely. And we must now there's no effective democracy. Citizens always have the lead. Agree.
Okay, thank you very much. I'm going to Dinah to begin the conversation with her, but because she was in this office previously, she may have something brief to say about all that we are saying. Hello, Dinah. Thanks for joining us.
Yes, thanks for having me. In fact, I was beginning to think that you had forgotten I was online because I'd hoped to join physically. But as you are aware, I'm also speaking I'm also a panel speaking on the theme for the mid-year conference of the GBA, which is happening as we speak. So thanks for indulging me to join you. Absolutely. As a human rights advocate, my whole learning training has been hinged on human rights. And so I do agree with you. And in fact, relish the engagements, the conversation that is going on there. As is expected of every jurisprudence, that continuously we need to do a check of our human rights framework. But of course, I'd hoped, and something I'm glad that later you redefined the comments you made, I'd hoped that coming from the office where I've been before, even there wouldn't have been the affidavit in opposition in the first place. So I think that is a comment I think later you addressed. But coming from that office, I'll tell you that no affidavit in opposition of that nature will emanate from the office of the AG without the AG being aware. It's good that now we don't have
This one, the application is actually from the state, so it will not be an opposition from the state, right?
So the objection, the withdrawal of the application by the AG the application shouldn't even have started in the first place.
Yeah, that's the point.
In doing justice to the conversation, you should have addressed that.
Yes.
But thank you. I agree with you totally. You and I think when you introduced me, said you're mate. I've always been a human rights advocate. I've shared this view. Of course, currently, the status is that it should be in accordance with the Public Order Act. And I've always maintained that if the conversation is that we have a real look at the existing law on demonstration, I am all for it. After all, it's the voice of the people through our representatives in Parliament.
If I may ask this, do you remember a single occasion where you supported the demonstrators against the police going for an injunction? Because there were even times you went for an ex parte injunction and we had to criticize you for allowing that.
Yes, you are assuming that the fact that you didn't hear from me on that side suggests that I was against it. I have maintained, and I spoke on the demonstrations when it happened, that there is a law. It is defined, there's a balancing act where there's a human rights are involved. And I have always maintained that it should be in accordance with the Public Order Act. It is different when you're saying somebody is acting, whether the AG or any other officer, contrary to the Public Order Act. And then we can have that conversation. But as the Public Order Act provides, and we feel that we need to close some gaps as we've identified in the Public Order Act, that is a different conversation.
Well, not about you personally, though, but I think some of the things that happened were extremely concerning and disturbing and really terrible, indefensible. But that was your job. You had to defend.
Public Order Act. No, I didn't have to defend.
I'm talking about even where you went for ex parte injunctions. I remember there was an ex parte injunction which granted the injunction in perpetuity. Yeah. It took the Supreme Court to set it aside. Yeah. On that occasion, I actually described the judge as incompetent, because if you're a judge and you don't know the basic rule, that you can only grant for 10 days and you grant for forever, that would be terrible.
And that's what I think I've texted you on the site to tell you that I disagree with some of your comments. The fact that you are dissatisfied with a ruling of a court or a judge in itself, there are rooms or there are fora for addressing this room. Are you suggesting, even remotely, that every judge must get it right? And whose right must he get it? Is it the right of an applicant, a respondent, or is it to get it right based on? So again, in exercise of the jurisdiction, it is not unusual for a judge to get it right, and that is why there are.
But for a judge to get such basic things so wrong, that's disturbing. Shouldn't it be?
No, something basic because you, Samson Ladin, says so. It may not be basic. It may not even be wrong in accordance with the other part.
No, it was wrong. The Supreme Court threw it away completely. That the judge was completely wrong.
But let's be sober.
It shouldn't have happened.
And in our comments and some of these.
It shouldn't have happened.
Always a two-side in every matter in court. One side will always be happy.
Okay.
Both sides may be happy, which is a given.
Thank you.
Fact one side is unhappy with the decision or dissatisfied with the decision does not lead to an absolute conclusion.
So that's that. Thank you. Let's go to the other matter, substantive issue. And as you say, it's a disagreement, but respectfully, of course, I also disagree. I remember speaking to Godfrey Dami on this show about that issue, and he sought to agree with me that even though the judge has made a wrong, he will construe it as limited for 10 days rather than for forever. Thank you. Now, let's go to the suspension of Justice Tokonu by the President on the advice of the Council of State upon the establishment of a prima facie and upon the establishment of the committee to, as it were, probe the matter. So, Dana, have you had the opportunity, for example, to advise the minority in Parliament or the NPP as they say that this is, let me quote what some of the comments that they have made, including at a press conference which Jerry Ahmed Saib, you and I, our mate, also had yesterday for the minority. They say the decision by the President to suspend the Chief Justice under the purported authority of Article 146 of the Constitution is nothing short of a brazen judicial coup, a reckless abuse of executive power, and a direct assault on the independence of Ghana's judiciary. This move, taken while legitimate legal challenges are pending before the Supreme Court, reeks of intolerable political vendetta, judicial intimidation, and a calculated attempt to pack the court with NDC sympathetic justices, as openly promised by President Mahama in Akosombo in 2023. Therefore, there will be a demonstration. What do you say?
Thank you, Samson. You asked if I've had the opportunity to advise the minority. I think you want to have a certain way to draw me out of my retirement, but the answer is no. But then you asked me what my view are. I think my view so far I've made clear, and I stand by that position, is that something. Again, we have to have a very sober reflection on the whole import of Article 146, appreciating against the backdrop that it is not a low threshold, and we should not sink our democracy by dilly-dallying or minimizing the effects, the import in the implement of Article 146. I have maintained, first of all, I've come out publicly to condemn the leakage even from government communication officers by posting it, some even on their Facebook. Now, again, you ask me what my comments are. And then I hear comments that say that, what has the president done? And that comment usually is laid with the assumption that there can be nothing wrong so far with the process. I reiterate, my position has been that there is no basis whatsoever for finding a prima facie case in respect of at least the 3 petitions that have come. And I'll go on to explain why. Can the president do something wrong in accordance with Article 146? Absolutely yes, because the whole purpose of Article 146 is guided by the Constitution generally and by the very provision of Article 146. Now we see the suspension, and need I say that Clause 10 of Article 146 gives permits by way of discretion, the exercise of discretion for the president to exercise this discretion to suspend the Chief Justice. And constitutionally, the exercise of discretion is again measured by the very Constitution in itself, Article 296, as elaborated in the plethora of cases by the Supreme Court. And so can the president fault? Yes, he can, in the exercise of discretion, where it is contrary to the very provisions of the Constitution. Now, coming to the very fact of this case, my position has been that there was no basis for the exercise of the discretion. And I'll say again, that first of all, if the only communication to the Chief Justice indicates without more that I have established a prima facie case in respect of the 3 petitions, the question is, will that alone suffice under the test under Article 296? I do not think so. Secondly, you look at the basis of these 3 petitions in substance to determine that even if on the face of it, a prima facie case may be made. Again, I do not think so. And I'll come back to it. Some, if you look at the petition of, is this Savior Group or so, where the thrust of the petition is on 2 fronts. The first being that the Chief Justice recommended to the president, giving some reasons why the number of justices on the Supreme Court should be wider, it should be more. And then you say that that is a ground for petition for removal. Practice, as you are aware, is that the appointment of justices all throughout go through a process, including consultation with GBA, Judicial Council, etc. In any case, that letter that the Chief Justice wrote was a mere recommendation. We know the import of recommendation or even advice to the president. It is not binding on the president. Indeed, it shows that the president did not even proceed to act on that advice of the Chief Justice. And so for me, I find it questionable how such points stated by the Savior Group can present a ground for the establishment of a prima case. Second, and most importantly perhaps, is that the thrust of the petition of the group is that the Chief Justice, while sitting as a panel member of the Supreme Court, and you and I know that the Supreme Court's jurisdiction, unless it is a single justice of the Supreme Court acting on behalf of the Supreme Court, usually is not fewer than 5 justices of the Supreme Court. And so if the basis of the petition, which then ends up in the final of a prima facie case, is that the CJ, who has 1 vote, just like all the other 4 judges on the panel, while sitting as a court, made certain decisions, gave certain orders that you are not satisfied with, the ground for it, I believe, is not Article 146. And I've always maintained that the Constitution and our laws in themselves present avenues for challenging decisions of the court. Now, I always tell people that I'll draw your attention to the very deep statement made by then Professor Justice Dr. Ba in the Judicial case, Now, if you remember, there was a preliminary objection raised by one of the parties that this is a dispute in respect of the petition to remove the Chief Justice. So how can the Chief Justice himself, then Chief Justice Akwa, empanel the member to determine this matter? And Justice Daktaba said something, and I admonish all Ghanaians to take a careful look and reflect on that statement. Indeed, he said, and I quote, that we, the rest of the judges at the Supreme Court, are not malleable clay in the hands of the Chief Justice. In other words, we have our independent thinking. We have our own, as it were, objectivity. So to suggest that we will be influenced by mere reason of the empaneling of the Chief Justice is unfortunate. And I do agree with him. And so for the petition to suggest that the Chief Justice, as part of the panel, as part of the court, made certain decisions, with all respect, is an insult to the rest of the justices that sat on the panel with him. In other words, they were so malleable that some of the decisions, which were unanimous, they were controlled by the Honorable Chief Justice. And I do not think that is a fair statement to make against the other justices of the Supreme Court. In any case, if you are dissatisfied with that decision where the Chief Justice presided, there are avenues for expressing that dissatisfaction. And secondly, when the Chief Justice sits as part of a panel, she could even be part of the minority. She could express a dissenting opinion. It is a decision. It is the order of the court. It is not a decision of the Tutokunu. It is, and again, let me go back. I don't like to even use personalities when it comes to issues of the judiciary. Especially, I mean, something is so coincidental that the first time I appeared on the show on Newsfile was in respect of matters on the judiciary, and have been consistent that in as much as we have the right to criticize, to be dissatisfied with decisions of the court, we have to be careful about not destroying the very tenets of our democracy. Because the judiciary continues, even on 6th January, when all the other arms of government are giving way after election to other parties of government to come into power. And so let's be very careful. And so to say that a decision of a court and not a decision of Tokon is a basis for establishment of a prima facie case, I'm afraid I do not agree to that. You look at the other petition by Daniel Ofori. Indeed, at paragraph 5 of Daniel Ofori's petition, he says boldly, and I quote, that I am not required to produce any evidence to support any of the allegations I have made in this petition. And that is a basis. In fact, we saw that, but for the request by the CJ for copies of this petition to even assist the court in determining these mere allegations, bare assertions that were made by Daniel Ofori in his petition, do we say suffices for establishing a prima facie case? I do not agree so. Again, in the same petition, he alludes to certain things that are including the exercise of some administrative functions without proof. And so something might fear, and that should be the fear of every Ghanaian, that somebody puts pen to paper, makes bare assertions, mere allegations against you, and that suffices as a basis for prima facie case. I believe we are lowering the threshold for the exercise of that constitutional process to remove no mean a person, but the head of another arm of government, which is the judiciary. Similar arguments can be made with respect to the Akogo Ayamda case. Again, and he is the only one that attaches a newspaper item to his petition. And go and check that newspaper reportage of Law Platform at that time. He said it is only Tokonu who caused for his arrest. Again, sitting as a panel. And in that same exhibit, which he attached to his petition, you will find that the newspaper reported that even Justice Kwama made interventions to him and said that you cannot be this discourteous to the court. You cannot be this violent to the court. In other words, your act, as it is now, is being in contempt of the court. And we do not see any of the judges signing to say that they did not agree with what happened on that day. And so something, I'm saying that I'm not being dismissive. If you have a grievance, if you have any dissatisfaction with any act of any judge, more so the Chief Justice, I'm not saying that we are gagging from expressing that dissatisfaction, but I'm saying that our very constitution and the laws we have given to ourselves provide specific avenues for addressing these grievances and dissatisfaction. If you are saying that the processes are not efficient, that is a different matter. Okay. And again, let me emphasize before I conclude on this that please let's not get the discussion wrong. The discussion for me has never been about personality. And that's why when I mentioned the teacher, when I go back and say I achieved justice, the discussion has never been about person. The discussion has always been about the office, has always been about the institution called the judiciary, an arm of government, which is normally part of the democratic dispensation, part of our democratic dispensation.
Okay.
Thank you.
So a couple of questions for you, especially because you take leave of us midway or very quick soon. And I'll be glad if you could just be straightforward with your answers and as brief as you can. So did you have to speak to this matter before the petitions were leaked?
Sorry, did I have to speak to it?
Did you speak to this? Did you speak to this matter before the petitions were leaked?
To it when it was leaked. The question is when you had it when it was leaked, but it had always been leaked, and that was the time I spoke to it.
Okay.
And found that if this is the leakage, then I'm afraid it doesn't cut it to meet the threshold for establishing a prima facie case.
So you are faulting those who establish a prima facie case that they did wrong. Is that what you're saying?
My position is that there is no basis for establishing a prima facie case.
Which is your view? Which is your view?
In accordance.
Okay. So you see, a while ago, we're talking about a judge's decision. And a judge made the most basic, simplest, fundamental error I don't expect any judge to make by making an ex parte injunction a perpetual injunction, which should never happen. And you said, you know, it's okay if a judge makes that and then it can go on appeal.
I did not say it is okay.
All right.
I did not say it is okay. I said that if you or any other person is dissatisfied with the decision, you see, if I can't say that judges making a decision, I'll be privy to the details of the reasoning they give for each case. So I'm saying that, are there avenues for addressing our views when we are dissatisfied with the decision of the court?
Right. So
in the confines of the jurisdiction, you can't get it wrong, and they do get it wrong sometimes. But is that a ground for an Article 147? I disagree with that.
Okay, thank you. So that is your opinion, that is your disagreement. And you will agree that your disagreement cannot override all the other people who may have been involved, particularly the Council of State, who would have been involved in the prima facie determination. So that's your disagreement. Now,
that their position makes a superior argument in accordance with the Constitution and the law, then I'll agree with you. But I have taken time to express my view in accordance with the law. And I'm saying that if your petition is that the C just sat as part of it.
No, it's okay. It's okay. Let's move on. Let's not repeat the points. Thank you. Let's not repeat the points. Okay, and I'm in a very difficult situation here, and I must confess, also because of the individual involved. But let me ask you this. So, myself, my senior, there was a matter in which a high court judge sat on, and we found that something wrong went on. So he gave a decision against us, but we had to appeal because we know we have to appeal. But we had to make a complaint. And in the complaint, the judge was found to have misconducted himself, and he was giving a reprimand. Let me tell you what happened. Any day we went to court, the judge had conversations on phone with the lawyer.
Without seeing the proceedings and the decision in that matter. I'm just...
If you allow me to finish.
Don't expect me to.
If you allow me to finish, please.
I'm just saying so that you know how to present the case to me.
So you see, when you were making your presentation, and that's what I do on this platform, when you were making the presentation, I gave you sufficient time to finish. Now I'm coming to ask you a number of questions on the things you made. So I'd like you to be patient with me in that regard. So I'm saying, to the point that you are suggesting that if a judge makes a decision sitting qua judge by Article 127, Clause 3, the judge is not subject or liable to any action, including in a court of law, for any omissions or wrongs they may have done in performing their judicial duty. That's the point you are making. So I'm giving you an example of a situation. Whether you believe it or not, that's different. But I'll not sit here and tell a lie about this. So we found that if I can ask, we found that this judge, any day we went to court, spoke with the lawyer on the other side before we went to court. There were times that the judge actually spoke to the lawyer after we had finished court. So we procured the telephonic record in our, complaint to prove that the judge had misconducted himself. So this is a situation where they have done their work in the courtroom, but we find something else to show that what they have done in the courtroom is wrong. You see that we are allowed to still challenge what they have done in the courtroom, even though it is not by an appeal, correct?
So something again, and you and I are not speaking different. I'll tell you what, if you read the Judicial case very carefully, Justice Tataba and the Supreme Court, they address all these issues. That it is not as if even the administrative action may be absolute for immunity. But what you are, the narration you're giving is quite peculiar. You are talking about ex parte communications with a judge and one of the parties. But we don't see a similar thing in the petition by the Savior or Hogoda. It says the court gave an order. It never said that the Tokonu had it. So again, that's why I keep saying that when you come to the nuanced application of the law, we may end up differently.
Okay. Now
there was no ex parte communications from the petition we saw. It says, and go back to the petition, that the court, that CJ presided. So I'm asking myself, what happens to the other 4 judges who sat with her? Why are they also not being removed? Because that is not a basis for Article 146 removal.
Okay, so the point I am...
The law, and that's why when the plaintiff lawyer and the defendant lawyer meet, they will all be invoking the same law, but it is in the application of it that lends itself to a judgment. The point, communications are different.
Okay, so the point I'm seeking by the reference I made was to bring to your attention whether you think it is possible that Article 127 may not always apply generally. Article 127, Clause 3 says, a justice of a superior court or any person exercising judicial power shall not be liable to any action or suit for any act or omission by him in the exercise of the judicial power. I'm not saying that any petitioner has suggested that there's an ex parte communication that they can fall the CJ on. Now, you say that the exercise of the discretion or the determination of the prima facie is not compliant with Article 296. How can you explain that?
So the exercise of the discretion in itself is not absolute, and the exercise of every discretion under the Constitution, as we see from 296 and as elaborated upon by the court, must have a basis, the test for the exercise of that discretion. And I'm saying that very basic examination of the petitions, it's that it is, I am aggrieved because the CJ was part of a panel that decided a matter in which I am dissatisfied. And I'm saying that is not a proper exercise of the discretion to arrive at a prima facie determination.
Do you agree that it is possible?
Let's all fear of the conversation that there can be no question whatsoever to the exercise of that discretion under the Constitution.
I'm not veering off a conversation. Wait, Dinah, hold on.
Let us veer off.
Dinah, hold on.
I tell you something. But I'm saying let us veer off that conversation.
Okay, Dana, hold on. Let me.
There will be nothing wrong in the Impeachment Article 146.
Oh, can we do this, please?
Particularly when is the exercise of a discretion.
Okay, Article 296 that you are referring to. Is it this portion that you are referring to, which says that where in this Constitution or in any other law, discretionary power is vested in any person or authority, that discretionary power shall be deemed to imply a duty to be fair and candid. The exercise of the discretionary power shall not be arbitrary, capricious, or biased, either by resentment, prejudice, or personal dislike, and shall be in accordance with due process of law. Is this what you are referring to? Is this what you are referring to? We're having a little difficulty with your line. Hello, Dinah. Hello, Dinah.
Of that
your line is breaking. I suppose, can we call her on phone so we can finish with her? Yeah, hello, Dinah.
Hello, can you hear me?
Yes.
Yes, I can hear you now.
The part I have read, is that what you are referring to?
Yes.
Okay, so I said the portion of the Article 296 I read, is that what you meant?
Yes, that.
Thank you.
Shall be.
I want a yes. I want a yes, then I'll ask you the next question.
Yes.
Thank you. Which part of this has been breached in the process? Okay, so let's cut it. Let's not continue to stay on the Zoom. It's not working. She should get on phone, and so we can quickly get done with her. Yes, so production, please get her on phone. That's how we do it, because we waste time. So she says a few things that we should not sink our democracy by this process. There's been a wrong use of discretion, not compliant with Article 296. Bare allegations have made a prima facie determination, and so on and so forth. And a judge exercising her duty in a panel is not to be singled out and blamed. And even in that manner, it is exercise of the judicial duty. So you can't even take it to any forum, including a court of law. So quick thoughts, Oliver, before I get back to her and finish off.
I mean, we need to go back first to Article 146. Article 146 says the grounds for removal are stated misbehavior or incompetence. What is a judge competent to do? It's the first question I ask myself. Because we say that legislator does not use two words where one will suffice. So if you have said misstated misbehavior and we have said incompetence, it implies to me incompetence in respect of the judicial function for which you're competent to perform. Okay. The mere existence of a forum to address incompetence does not eliminate the incompetence in itself. So if the constitutional intendment is that we want to do away with Kekewich, for those who are not lawyers, that Kekewich has become famed for a judge who continuously made wrong decisions, then that's the constitutional intendment. So it can never be the case that because a judge has made a judicial decision, that decision or by conduct had shown consistent incompetence on the bench, that we cannot remove that judge. We did not case ourselves with incompetent judges. So it's a strange argument. In fact, I remember years ago when that conversation you just had about that injunction came up. It affected us. And when you raised the issue with me, I said, I understand it, but I'm even afraid to contemplate it. Not that I am dismissing that it can be a possibility. So to come into the conversation now and say that this is absolutely not even within the constitutional imagination, I think it's a disservice to the conversation. Of course, the judgment and evaluation as to whether or not on this occasion the Chief Justice or any judge has been incompetent, that is the job of the committee that has been instituted to do. So we cannot say that any petition which raises the possibility of judicial incompetence should be thrown out ab initio. That I am struggling with will be my initial comment, I would say.
We get Diana on phone. It is important. She's the former Deputy Attorney General, a former Deputy Attorney General and Deputy Minister for Justice. Her party is the one that is rallying support for a protest. Her party is the one, the minority in Parliament, that is saying that what is going on is basically unconstitutional. And with the benefit, as a former Deputy Attorney General, we want her to educate us on the points that she agrees. My view is not important here, and I actually don't intend to speak about the content of the petitions for myself, but you are free to do so, like she has done. Now, yes, Inusa.
First of all, in fact, I will not go into the content of the petition. I am a constitutionalist. I understand the tenor of Article 146. I understand the reasoning and rationale behind the proposition that everything concerned with the removal of justices of the Superior Court of Judicature and Regional Tribunal must be in camera. I've read fully the judgment of Databa in the Ajechum and Attorney General and another, and he deprecated in forceful terms the leakage of petitions for the removal of the Attorney General. So let me say that I am going to restrain myself from talking about the petitions, and that is my shock in the account of the former Deputy Attorney General. What she has done simply is to substitute herself for the committee that has been established under Article 1466.
She's entitled to disagree with them. No, that's what she has done.
Well, so she disagrees with the committee and takes the petition, and she's now analyzing the petition and drawing conclusions.
She hasn't said anything new. She has simply repeated the responses, quote unquote, the responses from the CJ. That's what she has simply repeated to you. Hold on, I understand that Diana is back. Hello, Diana.
Hello, Sam, can you hear me?
Great. Good to have you back.
I could hear you.
Great.
Perfectly.
Yes.
I could see you. In
Okay.
fact, I could hear a response that the subject of the incompetence to the judge is not what we were looking at. I mean, absolutely, the ground is for incompetence. The view then is, what are the other judges who sat on? Because there was a decision not of the Chief Justice, but a decision of the court, constituted by no less than 5 justices.
Right. You say the prima facie was not compliant with Article 296. I'm asking, which part of 296 would you say has been breached?
Hello, Sam.
Yes.
Yes. That has been my position, that it was not in compliance with Article 296 and decided cases, and particularly when we look at the article the President has consistently made against just the 4 members of the judiciary, but especially in respect of the justice. I am saying again, I'm on another panel as we speak. Again, my position, I will reiterate, is that we not, in fact,
okay, sorry, we are unable to continue. The line is bad. Thank you very much. Thank you, Diana. I think you should go pay attention to the job you have to do. Yeah, go ahead.
Samson, you were saying that, well, she just repeated what the responses of the Chief Justice. The responses of the Chief
What is purported to be the responses of the Chief Justice?
What is
I want to pretend that I haven't seen
that is what is purported. That is very important, because you're a lawyer. You should know what is purported. And that's why, as a lawyer and officers of the court, we should give fidelity to the Constitution. If even these matters were acceptable to be put in the public domain, custody issues will come up. Where is she getting it from? Evidence in custody. Where is she getting it from?
She had actually said that leakage of the petition by some government officials. It was one of the questions I was going to ask her to show which government official she's referring to. And my viewers and listeners, this is what I do. Once you make allegation, I hold you to prove the allegation. And sometimes, you know, the partisanship of how you view the things, you say, why are you doing this? But I have to do it. Even if I have seen one, I still need the person to prove them. Okay, so yes.
So for me, we can continue talking about what this conversation is about. But my position is that there's good reason why Article 146 is in our Constitution. It is to ensure judicial accountability. And there's also good reason why you need a judicial tribunal as advised in the 1969 Constitution, which in the 1992 Constitution is a tribunal to determine whether there's a prima facie case. I mean, why you need a Council of State acting in consultation with the President to determine a prima facie case, and you need a judicial tribunal to subject the person, the respondent, to trial. And the respondent must be given all opportunity under Article 146 to defend himself or herself. So the fidelity of the process is what we should be concerned with. Whether the rights, and I see a lot of rights, I also see a lot of constitutionalism embedded in Article 146. I mean, any day I look at the Constitution, Article 146, I say, wow, the design appears to be perfect, even though we've been criticizing the Constitution. First of all, the whole Article 146 is not about the Chief Justice. It's about the removal of justices of the Superior Court of Judicature and regional tribunal, because the regional tribunals are part of the Superior Court of Judicature. Now, look at how the Constitution proceeds. If the matter concerns a judge of the Superior Court of Judicature, what is the role of the President?
Zero.
Zero.
Postmaster, conveyor belt.
Zero.
Receive the petition and give it to the Chief Justice.
The Constitution doesn't say that the Chief Justice is to determine whether the petition, the Constitution doesn't say that the Chief Justice is to determine whether the petition raises a prima facie case with the Judicial Council.
It's a sole job.
It's a sole job.
Absolutely.
It's a sole job. Now, but the Chief Justice is a justice of the Superior Court of Judicature. So, and again, head of the judiciary, when a petition is against her, you can't send the petition to the Chief Justice to determine whether a prima facie case has been made against her. Naturally, it will raise the concept of natural justice, being a judge in her own cause. What does the Constitution do? The Constitution imposes an institutional limitation on the exercise of the power of the President. Because Article 58 of the Constitution vests exclusive executive authority in the President. It says the President cannot do it alone. He cannot determine whether the petition raises a prima facie case. He must do it in consultation with the Council of State. And if Ajetum is to be a guide, the Taba says the Council of State must play a prominent role in the decision. So as constitutional lawyers, what do? We want to see that the process is followed. Why is it so? So that to protect the Chief Justice against a capricious and vindictive executive. That's why it is so. That's why that limitation is on the exercise of that power. Now, so even though and I agree entirely with the reasoning in Ajetum, even though Article 146 does not include prima facie, but it stands to reason that because the Chief Justice is a justice of the Superior Court of Judicature, you probably will flout on Article 17 of the Constitution if you do not establish in her case a prima facie case. And so, apart from the reasons given by Databa in the Ajetum case, you can't treat people differently equally circumstanced differently. So, the prima facie case is determined. And when the prima facie case is determined, again, there is a procedural limitation on the exercise of power of the president. Article 46(10). That decision to suspend must be in accordance.
I understand by my production that we have Diana back. Hopefully, we can do this very quick because it's getting unnecessarily prolonged because of the hitches that we're having. Hi, Diana. We lost her. I think, did we lose her? The line dropped. So you see, these things will be going on. People will be raising their own suspicions about what is going on. I'm tired. I don't want to continue there. Let's continue here. It's enough.
So you see a procedural limitation. The suspension must be in accordance with the advice of the committee established under Article 146. And that must be fair. It implies that discretionary power, even though constrained by Article 146, because that discretionary power is not invocable. It must be exercised in accordance with the advice of the Council of State. Now, so you must measure it against Article 1296. Is it fair?
Is it candid?
Is it candid?
Is it capricious?
Is it capricious?
Is it with
is it in accordance with due process? As lawyers, as governance experts, we want to see that there's process integrity. Because if there's lack of integrity of the process, it might lead to a violation of the right of the respondent.
Dana is telling you that there are petitions without any evidence, bare allegations. As far as she's concerned, bare allegations should not, lead to a prima facie determination.
Bare allegations, weighty allegations, whatever the nature of the allegations, a procedure has been provided in Article 146 of the Constitution. We must trust in the procedure. What we are doing is bastardizing the procedure. Look, Article 146, again, is about judicial accountability. How do we ensure, as a people, because Article 125 says that justice emanates from the people. How do we expect to hold judicial officers accountable to the people of this country?
The Judicial Service has a complaint process. I just mentioned one to you. We complained about a judge. We went through the process. He got a reprimand. We're not excited about that. But that's accountability. I've had someone, a judge, walk into a banking hall and conduct himself in a way that the teller was not happy. I had to represent that teller in a complaint process before the Judicial Service to investigate that judge.
But this particular provision raises your complaint process to constitutional levels. That's what it does. It's so important that the conduct of judges of the Superior Court of Judicature is brought under a level of examination that meets the provision of Article 146(1) of the Constitution. And I have said repeatedly that there is an onerous responsibility placed on the guardian who wants to bring a petition to remove a justice of the Superior Court of Judicature, including the Chief Justice. One. And I've said, frown on your face against a former president might not meet the conditions stipulated in Article 146(1) of the Constitution. Is it stated misbehavior?
The thing I was asking you is, you said, how else do we hold them accountable? And I was I was suggesting to you that it is possible there are other avenues to hold them accountable. There's a Justice of the Court of Appeal who was, in delivering his decision in the High Court, encountered a problem. He's now a chief. And he was faulted for having done something wrong by the Supreme Court itself. They use very, harsh words on him, a committee was set up to investigate his conduct. I appeared before that committee because I was in court that day when the thing happened. My case was called before that case. That committee had Nana Megache, Elizabeth Ohene, a couple other people. So there are other avenues other than seeking to remove someone. That's the point I'm making to you.
Yeah, you've answered the question by yourself. I think 146 is seeking to remove. It's not seeking to discipline.
We should leave the decision to the petitioners.
We should leave the decision to the petitioners. If they want to discipline at the statutory level, they take it. So when your client complained about the conduct of a justice of the Superior Court of Judicature, that justice was disciplined, but still at post. Article 146 is about removal.
Okay, in fact, if they complain about the Chief Justice, I doubt
whether
that can happen.
That can happen.
Okay, let me go to
well, but I've not finished
briefly.
Okay.
Yeah, hold on with your comments. After having heard from Diana, I wanted to ask you the minority and the MPP's position leading to the demonstration they intend to have. What do you say?
Samson, I'm not a lawyer, and I feel blessed to be in the midst of crack lawyers, and I've been enjoying this, but still, being a pedestrian in law, I'm still lost in many ways. But fortunately, governance is not that strict with interpretations, because you have legal side, you can have a social side, political side, all sides in governance. So I'm not able to respond directly to Diana's presentation, because you all have argued for and against her position. With regard to the demonstration, as you asked, well, in the first instance, our initial comments were with regard to their right to do so. And I think that should stand. As to whether Diana had advised them on the legalities and the appropriateness of it, I have no idea about it, right? But let me say this. The issue certainly is fundamentally legal, as all of you have argued. And because I'm not a lawyer, I'm not competent to go that way. But there are certain aspects that I think is of interest to all of us. You look at governance generally, and I think my friend Yusa alluded to that. We have three important legs in governance. We all know that. The legislature, the executive, the judiciary. And for the sake of accountability, we go by this theory of separation of powers, which we try to actualize in governance. And also, we have this notion of the independence of the three entities. So my interest here is within the context of that, the governance. Where are we going with this particular case? First, let me take the notion of the separation of powers. Whether this particular incident breaches that notion is of interest to me. Because if that notion is breached needlessly, it creates a crisis for governance. Not only that, as a fledgling democracy, it also gives some very wrong signals to ourselves as aspiring Democrats and to the world out there. And I've had the issue of the use of discretion or making decisions. Let's not forget that this is not the first instance petition has been made. At least in my lifetime, I won't go far into history, but the petition that removed Charlotte Osei.
And her two deputies.
And her two deputies. From what we know, that petition was submitted by one individual. As I sit here, I don't even know the name of the person. And we're told at the time when issues were raised by the president.
I think it was submitted by a number of individuals. Began with a nameless individual.
Nameless. So how many in all? Do you know how many people were involved in that petition?
It was a couple of people, I think.
Okay, let's say a couple of people. And the president told the country that he was simply a conveyor belt, suggesting that perhaps he did not even review the petition and simply submitted it. So the process went on, and we know the outcome. That, in retrospect, could have been a very bad decision on the part of the president, setting a bad precedent, I should say. Not that citizens don't have the right to petition, but I think when you are dealing with a position as important as Chief Justice, I'm skipping from the Electoral Commission side, I think there must be serious introspection. Again, because of the issue of separation of powers here. And if you go into history, there are instances where presidents have been very angry with Chief Justices. And if you look at how they have dealt with them, it gives you some guidance. Because in a democracy, the last thing you want to see is for the executive behaving in any way as to undermine the other branch of government, in this case, the judiciary. So presidents have been very circumspect. In fact, they've constrained themselves.
What's the point? The petitioners bring petition. The Jubilee House should refuse them or receive them and trash them, or what?
As it is, you've got to follow the process. That's why I enjoyed the presentation by Inusa. The process, our constitution as it is, you have no other option but to proceed with the process, except to say that when it's submitted to the president can decide to move it forward or not to move forward. I think towards the elections, there was one petition that was submitted to the president, Akufo-Addo. We all saw the response he gave, apparently claiming that there was no prima facie case there.
Together with the Council of State.
Exactly.
And Uncle Sam Okujeto has been speaking about it. They considered it and found that there was no merit in it.
Exactly. So that was one way. Perhaps it was an option to avoid this interference in this separation of power notion. But in this case, the president had decided otherwise. And you cannot fault him because he's following the process.
Is it the president who has decided?
Well, it was first submitted to him, wasn't it?
Correct.
Did he review it himself?
Prima facie, according to the Constitution, is done by
the Council of State.
Acting in
consultation with the president.
So the president saw it. And he could have decided
that
perhaps it's not worth proceeding.
So
as
he
an
does,
option.
So he does what with it?
Pardon?
So he does what with it?
If he decides it's not worth, as Akufo-Addo did, he could have also written to say, look, I receive it, but it's not worth. Or is the president obliged to proceed by all means? I guess, again, you are the lawyers. Let me understand. I guess what I'm trying to say is that the central point here is that it's always important to protect that principle of separation of powers and the independence of the three entities. That's the essence of my discussion here. So unless...
Hold on for a minute. Okay. Oliver, can you help him out with what he's sort of seeking a response to about what the president could or could not have done with the petition? The president receives it. From his presentation, Akufo-Addo received one, and he reviewed it and decided otherwise. John Mahama has received 3, 5, and could have, or was it?
I think I understand the first reaction that we must protect the office of the Chief Justice as much as we can. And the conversations we are having now is a test of our constitutionalism, and we must, as much as we are witnesses to the process, we are all, or should all, be interested in process integrity. Okay. So far, our constitutional mechanism has provided that the petition, once received by the president, there must be an opinion on it, whether or not it meets a prima facie standard. The determination of what amounts to prima facie, there has been back and forth discussions about it. There's no question about it. In this case, once the president receives it, I would not join any discussion that it is in the interest of separation of powers or even in the interest of protecting the office of the Chief Justice that you must trash the petition as received because of any consideration. If we want by constitutional means to elevate the standard by which the removal of the Chief Justice occurs, we are entitled to. So far as it exists, the process is that we must determine whether or not the petition as it exists, just by a prima facie just by looking at the record, are the allegations made, if assumed to be true, does it raise an issue of misbehavior, stated incompetence or infirmity of body and mind? Just that. But we must remember that this is only a filtering process. It is as if the conversation is being had as this is a foregone conclusion or the Chief Justice has gone home.
Is the prima facie determination that of the president?
No, the prima facie determination, well, it is by the president, in fact, if you follow what the Supreme Court is saying. Because the Supreme Court is saying that in consultation means that you are seeking their advice, but you make the ultimate decision. This is one of the reasons why there's a cause for concern, because, first of all, we have a court that is saying that we should not know what the content of the petition is. We should not even know that the petition has been made. Now, if we want to go into proper governance, and this is what my concerns has been, that we have essentially thrown the president under the bus. We've thrown the president under the bus because everybody then is presuming that this is something that is orchestrated by the executive to remove the Chief Justice. It could not be so.
And you just made a statement, and I think I'm hearing that almost like for the first time. So we need to be very clear about something.
So this is what
I want to guide you this. On this. We have read it over and again, but it's important to read it. Sometimes in the middle of the discussion, we may forget. Where the petition is for the removal of the Chief Justice, the President shall, acting in consultation with the Council of State, appoint a committee consisting of 2 justices of the Supreme Court, one of whom shall be appointed chairman by the President, and 3 other persons who are not members of the Council of State, nor members of Parliament, nor lawyers.
Yes.
There is no a requirement for the President to make a prima facie.
Absolutely.
Then a J. Chum,
yes,
in 2005-6, correct?
Yes.
Comes in to say there must be a prima facie
determination
to be done with the Council of State.
Yes.
Senior Uncle Okujeto tells us that they, the Council of State, are the ones who do the prima facie.
Yes.
As we are learning, there appears to have been some voting with some people or one person abstaining within the Council of State. Is that correct?
Yes, that's what we have been advised.
So how do we say prima facie is the decision of the President?
The reason why I say this is that what is law and what is practice can differ. The Supreme Court is telling us that when the President must make a decision in consultation with the Council of State, it is the President's decision. He's only consulting and may decide whether or not he's bound by it or not. That has been the position that the courts have taken us to. Now, there's no reason which would prevent a president saying that because I want no hand in this, I'm going to entirely leave the decision in the hands of the Council of State, which, from what we understand, appears to what has been done. Now, it is a serious case that the Council of State, appointed so, would by unanimity, excluding one who abstained, not voted against, decide that this meets the bar for us to establish that committee. We cannot rubbish those complaints or even insult the intelligence of the persons who have made those decisions. There is, in fact, 2 judges on it. One, the former Chief Justice, who has held that office before. Now, irrespective of our feelings as to whether or not what precedent does it set, where does it move us to, we must never deviate from the question as to whether or not so far there has been process integrity. So that's the beginning part for me. One of my biggest concerns, however, generally in this conversation, is that we are beginning to see this issue mirror our political divide.
So can we establish one small point? If the prima facie determination was made by the Council of State, is the President bound or not bound?
Legally, no, not bound.
The President can say, you have made a prima facie.
By what the Supreme Court has said.
No, it's not advice.
Pardon? So the Supreme Court says, so when you look at both GBA decisions and all, they have taken both the question of advice and consultation with and determined that the ultimate decision maker remains the decision maker. So by their own doing, they then put the responsibility on the President to make that final call.
Okay.
But it is prudent, as it seems to be the going practice, or at least what we imagine, that the President decides that I am going to abide exclusively by what the Council of State has done. In this case, we are being told that the President has decided to submit his decision-making to what the Council of State has done. So this is, in fact, a decision that, well, even though legally the President owns it, practically, this is a decision made by the Council of State.
Yes or no? The President can say, prima facie, I don't take it. So what happens?
So that's the problem. So
I need to take a quick break.
So we have been boxed into a corner where we have to reconcile what the Supreme Court is telling us on the implication and meaning of...
No, I need you to agree or disagree that when the council, if the Council of State is the one that does the prima facie, they can finish and say, we have found that the Chief Justice should come and answer in a committee, and the President is entitled to say, I don't agree with your prima facie. Is that correct?
I don't think that the President
that's what he just said.
Advised. A President can say that, but I don't think that a President well advised will do that. Because clearly you'll be
okay,
setting yourself up against condemnation by the people of the country.
Imagine the President says, I don't take your prima facie, then what happens? He will make his own to establish that there's no prima facie, so no committee should be set up.
Well, in fact, it seems to us that the petition against that brought the last time was brought by Kwekwaza. We don't know actually what the Council of State recommended. What we know is that the President says I have consulted and I have made this decision.
And some people has given us more information that they did it.
Decisions in terms of the are not made public. Yes. It's not made public.
It's difficult to say.
No, I'm asking a practical issue.
Yeah.
If it's the Council of State that makes the prima facie, and you suggest that the President can say, I don't take your prima facie, what happens?
That's why I don't think that in the case
dies.
Yeah, that's what I think.
No, it's really dangerous.
How will it go?
You see, it's very dangerous.
This is the loophole.
Thank you. And the Constitution will not have been breached.
Very dangerous. Uncharted territory.
I have never disagreed with Judicial. Yeah. I know that it is the consensus of many people.
We'll take a quick break. We'll be right back. Yeah.
I don't agree with Judicial.
Dangerous,
but
this is authoritative news. And here on Newsfile, we put Ghana first. I've got some of your comments. I'll share them with you in due course. And Dr. Asasante and the rest of you, I'm seeing all of your comments. I'll share them with the rest of the world. Now, I will quickly return, and Prof, you were the one speaking, so I will come to you, but I have to go to Diana Sonabadapa quickly. When you were talking, one of the comments, questions I've had from viewers, one of it is that it says when the judiciary through the Chief Justice were hacking the executive, we said it was the judiciary holding executive accountable. When the executive holds the judiciary accountable, we say it is witch hunt. And a colleague professor of yours is asking the question, please ask Prof, which aspect of the process has so far been breached and for that matter poses a threat to governance or democracy in this country? But get ready with your answer to that. Dana, I hope we have a clean line to you now.
Yes, and I mean, thanks for bringing me back. I hear at the bar conference, so I'm being called because my session has started. But thank you for indulging me.
Thank you. So do you agree with the minority and the NPP that they should go on a demonstration to force the hand of the president to stop this? Because that's the clarion call. FIDA, they all say stop this process.
Thank you, Samson. I think it's interesting that at the very start of the discussion, we're talking about demonstration, and I've expressed my views that it is an inalienable right, and you agree with me. And so I agree, but it's the part about today to force the president's hand. It is not necessary. It is just not about forcing it is only because it is the constitutional thing to do. And it is provided for under Clause 11 of Article 140 that the president may revoke the suspension. And for me, I think we should situate the conversation properly. And forgive me if I'm rushed, because again, I'm also getting calls to be at the Newsfile conference. But let's situate the conversation properly. It is not as if, you see, the question that what has the president done? And I keep responding that the president is acting, is provided to act in accordance with the Constitution. And so conversely, he may act on I'm rather surprised that there's nothing wrong. And I said, no, there has been something wrong. Looking at an application of Article 140 to what we are witnessing, that it is a court decision and it is the Tutokunu. What about the other judges?
You are saying
that you feel your human rights have been violated. why not invoke the provisions under Article 33? And particularly worried is how low we are sinking our democracy and the threshold for removing no other person but the head of an arm of government, the judiciary. I do not say that they are not without.
Do you recall?
Judiciary propriety, they are not.
Do you recall that in Charlotte Osei, for example, that she was arrogant and she had not met some AU people, executive, and so on? All of that was part of the petition.
But Samson, you yourself took that action to court. The determination was whether or not a constitutional question has arisen. And the Supreme Court decided on that. And I, Diana Asnabadapa, I respect and defer. I may not necessarily agree with any court decision, including the Supreme Court, but I respect and I defer to that decision. And so please, let's be very careful.
I ask you a specific question. You are talking about raising the bar of what should lead to a removal. And I'm saying that in one petition, someone was alleged to be arrogant and not meeting AU executives and so on. All of that was part of that thing.
Was that the sole petition? So let's not glorify some of these. In any case, without seeking to denigrate the office of the EC, it is incomparable to compare the office of the EC.
It was a serious matter. Let me tell you this.
Head of the judiciary.
Let me tell you this.
Situate the conversation.
It was such a serious matter that in her response, she had to put a picture of herself in the meeting with Thabo Mbeki to show how not arrogant she was against that allegation.
So is this analogy and what is the end game of this analogy and this conversation? I do not seek to respond to fleeting arguments and all of that. My point is, let's situate this conversation properly. I respect the office of the EC, but my respectful submission again is that it is incomparable to the office of a head of an arm of government. Okay. And every Ghanaian must be worried how we are denigrating, how we are lowering the threshold for establishing a prima facie case. Every Ghanaian must be worried that the final bastion of our democracy, the judiciary, we are undermining it, we are interfering, especially with the very disturbing prejudicial statements that have previously been made by no less a person than the president and officers of this government, targeted at the chief justice. Very prejudicial statements, unwarranted, and a grave affront to our democracy. Again, I'm so sorry I have to be because
all right, thank you very much. We end it here. Thank you very much. Enjoy your program. Now, let's come back here. And, some of these things, I really find myself in a bit of a difficult situation because I led the process for Richard Nama to remove Loretta Lamte. And I won't say further. So the question I ask you, what do you say?
Yeah, the person was asking if the president has breached the process. Not at all. In fact, nobody can fault the president for what is going on. He's simply following the rule, and I do respect that. Okay? So my issue is extra to these legal matters. So when I raise the issue of separation of powers, it's not a legal issue. It's a principle in governance that I want us to sustain. So anything that will be done to undermine that or weaken that, I think we should guard against that. That's my point.
The question was that when the judiciary was doing things, we were happy that it was holding the executive in check. When the executive has to play its role, now we are saying there's a threat to the democracy. Diana says, we should not sink our democracy.
The executive, look, this is not something initiated by the executive. I don't think you should say the executive is playing. A citizen got concerned about the behavior of the Chief Justice and file a petition. So this is not coming from the executive. Again, that's where the problem is. Once you conceive the executive to be doing this, then it's even more dangerous. I don't think the president is doing that. The president is simply responding to an issue that he has a responsibility to address. He received the petition, he carried on the process. My earlier point was that perhaps at his level, he could have decided otherwise. But he chose to send it. And if you go into history, look, there have been instances where presidents have taken different positions on such matters concerning the Chief Justice.
They have actually received petitions and shelved them.
Precisely. Because they are...
And we're the same people who complain when we got to know that they received the petition and sat on them.
Yeah.
Well, in this world, Samson, even people complain about you. So what's your problem?
They complain about how I smile when election results are being...
so that is no issue.
Okay.
But I think I've also been hearing about the threshold. I think, for me, I'm happy that this thing has happened at the time that there's a committee to review the Constitution.
Great.
Because these are some of the issues that we need to deal with, to bring some clarity. For instance, I think, as the lady said, the threshold for petitioning and getting a removal of Electoral Commission chief and now the Chief Justice is woefully inadequate. You see, for the president and even his ministers, it has to go to Parliament for 2/3 majority to accept before anything can be done. In this case, a single individual or individuals submit a petition, and then the Chief Justice is obliged to respond to each of them. Then, of course, the process, as you say, is now ongoing. I think it's not a proper way to manage a problem having to do with a Chief Justice. Maybe my conception of Chief Justice might be a little bit exaggerated, but if I consider the fact that Chief Justice, President, and the Speaker, these are the three kind of centers of our democracy, then I have to be more careful, especially looking at the principle of separation of powers. That's my concern. So I'm not here, earlier you thought was being political. No, I've not done anything wrong. But the whole process, as we have it today in the Constitution, needs to be reviewed so that we can streamline and raise the bar. Look, in some jurisdictions, you know that this petition should have been backed by a certain number of signatures to show the widespread disapproval. I know of a poll that came out to say 42% or whatever. But if you can attack...
That was unwarranted. It should not be allowed. How do you do a poll and poll people who do not know the content of the petition?
Thank you very much. Thank you very much. That's why in some jurisdictions, they require that your petition should be backed by maybe 100,000 signatures or 10,000, whatever the number may be determined. It will show the gravity and the widespread support for that particular movement. But if you get one clever lawyer, like my brother here, to write a beautiful petition and note all these things and submit, that alone then kind of ignites the process to remove a Chief Justice or Commissioner of Elections. So I think...
But the allegations that people make, they will be required to prove them. And the parties that the allegations are against will be required in the process to challenge them. They will cross-examine the people. They will vet their evidence.
In practice, Samson, in practice. We've seen it before. So in the case of Charlotte Osei, how many people went forward to dispute it? How many, in terms of society, how many civil society sorrows?
No, I'm talking about the main process. You will know how many witnesses were called in the process. I've done this process before, so as we speak, my mind is in the committee room and how the thing was done. Witnesses called, cross-examined, evidences procured, and how they were used and so on and so forth.
Yeah, I agree, but still, I think we need to raise the bar for petitioning and the petition being accepted by the president when the Chief Justice does something wrong.
Yeah, Oliver, what do you say? So when I led Kwekubako to the Supreme Court, Diana says we raised matters of constitutionality and the court disagreed, and she agrees with that decision. In fact, there's no decision that you find and read. That process in that courtroom, I don't want to ever speak about what happened on that day. But there's no decision that you can find and read what happened to that case that was filed.
Why?
Yeah, that's part of the judicial impunity.
You know, in that case, we were raising the question that they should help to define, there should be rules pursuant to Article 296. There should be an instrument to define how these petitions are managed. We should define what is incompetence, what is status misbehavior, so that if I commit,
you know,
say,
another infraction,
a procurement infraction, whether the procurement law should be used to deal with me or it should be basis for my removal.
That's right.
We asked all those questions. In fact, I remember, I looked at the judges and I said, you are endangered if you don't allow the process to provide for rules. And I remember some of them replying me, we'll take care of ourselves, leave us alone. Yeah. Is the threshold too low?
First of all, I don't necessarily agree that the threshold is low for the question of determining whether or not a committee ought to be put in place to investigate and, in fact, test whatever allegations are being made. Because if we continue to view the process as starting and ending when the president makes a prima facie determination, would be led into that thinking. One of the first times I discovered was based on the article you had written. As to the first person this was exercised against, James Opon, or I think...
Yeah, James Opon.
James Opon.
Deputy NCC. Jacob Opon, correct.
The allegations against them that went to the Supreme Court was one, that Larry Bimi then, as chair of the NCC, had asked him to swap offices, which he refused. And the second one, that he had made a sexual advance in respect of a staff. The Supreme Court considered that these were grounds which are sufficient to meet the standard of misbehavior. This was the Supreme Court's decision. Okay. Now, we are all trying to avoid going into conversations around what the petition entails. It is very difficult for me to say that the Chief Justice, allegations of financial impropriety were made, irrespective of whether or not the persons have provided proof, because that's for another process. The Chief Justice has been engaged in removing and transferring judges of the Supreme Court for reasons other than administrative efficiency. That it is alleged that it is influenced by other reasons. Whether or not this is proved, it suffices for us to inquire more. That's my question.
So the bare allegations...
The allegation...
should be enough.
For me, the allegation, as long as an allegation is credibly made. This is not the point where you have to test and retest the evidence. If we transform the presidency into where he must shift through evidence and give evidential weight, then we are even politicizing the process more than it's required. There's a reason why in one instance it's only a conveyor belt. Because we don't want it to be politicized. In this case then, if the Supreme Court has determined, those who can look after themselves, have determined that the president should be involved in determining prima facie case, I do not want a situation whereby, in the same way the president can be displeased with a Chief Justice, a president can be pleased with a Chief Justice who does his bidding. And for which reason he will be interested in keeping that Chief Justice in office. Oh. So if there's another layer of a process, that all those who have made those allegations will come forward and then prove that allegation, and it is fair. I am extremely disappointed, in fact, that the process and the muddying of the waters is being led by the former Attorney General and the Deputy Attorney General. I think that their role in this process has not enhanced the credibility of the process, but only undermined the integrity of how we should go forward. And some of the comments that the Deputy Attorney General was making on there, I am shocked to hear her speak like this. Because all of us here even have known, the wisdom of restraint as to where we want to talk about the process generally, without even going into the substance of allegations and determining on our own basis whether or not that suffices. So some of the positions he has taken, I find them shocking. Even the suggestion that the Chief Justice was a member of a panel, and for which reason we cannot isolate misconduct by one individual in the power, flies against everything that we know in law. The fact that 4 people have been accused of a crime, it is no defense to say that one of them has been brought before a judge, and so for which reason you should be excused from liability. I don't know.
No, but it's not fair to say that they have done something collectively.
The question is...
a decision collectively, and then you single one out.
The question whether or not in terms of a collective decision, the question here is not whether or not the Chief Justice was wrong to make a decision. It is interrogating the process by which she made a particular decision. That decision and that determination, we can be sure that Justice Poamang, Justice Asidu, and the 3 other persons who have been brought on board can reach those decisions fairly and determine that as for this is out or on. But importantly, there are 3 petitions before the Supreme Court. Even though we say there are 3 petitions, in fact, the allegations are more than 3. And so one individual can make several allegations. On one, there might be a prima facie basis. On another, they may disagree. On the other one, the committee might find that, yes, this is a ground enough. On the other one, they might dismiss it. So it is not insufficient to pick and choose the one we think is weakest, and then criticize the entire process of being orchestrated to remove a Chief Justice.
But doesn't Dinah and others have a point? 3 petitions.
Yeah.
I remember in Loretta Lamte's case,
yes,
there were more than 1 petition.
Absolutely.
Okay. I've heard people say Anodompre and Richard Nyama. No, the petition that succeeded in the prima facie was my client's petition, which is Richard Nyama. So it was only Richard Nyama's petition that was used. Yeah. Anodompre's petition was not used. Forward. How come that all the 3 petitions succeed in prima facie? When as she looks at the petitions, some of them, they could have thrown them away.
Well, let's look at the 3 petitions from what I understand, because particularly for Professor Kweku Asari's petition, the one that we know of and the allegations that were made in the past, several of the things that Daniel Oforo is alleged to have said are repeated from there. So they are cross-cutting some of the issues raised. The bigger one, if you were to ask me as an individual, the bigger question that I'm a bit concerned about is the one that was made by the police officer in terms of allegations that records of the court were changed and things like that. Without going into evidence, we cannot hear an allegation like that and say that let's dismiss this and throw this away. We must, in fact, interrogate that. And it is possible that the committee might find that the Chief Justice did wrong, but it does not arise to the level of removal. The committee is entitled to do that.
In the performance of their job as judges, is it far-fetched for a judge to see that a lawyer is behaving unruly, is misconducting themselves in a way that they are entitled to call the police to pick them up and detain them? Okay. Is it wrong?
The principle that a judge, where a person's conduct is interfering with proceedings, a judge is entitled to. The principle itself does not obscure whether in the factual circumstances of this case, because the allegations the person is making is not only the impropriety of having been arrested, but also that because I wanted to take further administrative actions, I sought to procure the records of what actually happened and found that these have been changed. That it was, in terms of a search file, it was said that, no, you were never arrested. These are allegations which, again, I am not in a position to prove or disprove. The committee then of senior judges would interrogate this question.
The CJ doesn't have custody of the record.
The question as to...
The records he's looking for. It is those who are manning the CCTV process or recording process.
This is an interesting point then for the committee to then go into. That if you are alleging that the Chief Justice was involved in the process, how was he so involved? When I have gone before a high court, before the record is given to you, they tell you that the judge must look into it first.
That's correct.
I have had rulings made orally in court because we have stenographers who are typing what the judge is saying. And when you apply for it, it is different from what was read in court. It happens all the time. It happens so many times. They may even change words. Okay. May retain the substance of it.
Okay.
The question now for us is for this body to determine whether the series of conduct is sufficient.
I need to take a break here, but it's only fair to give you a minute or two. What's your final comment? There's going to be a demonstration and there's a call on the president to stop. Yeah, do it quickly.
First of all, Doc has said that, well, to remove what do you require to test majority? The president or something of parliament? Now, so let's go back to constitutional history. This provision in our constitution emanates from the 1969 constitution.
Yeah.
Okay? In 1969, the drafters of the constitution said, no, let's insulate the removal process against partisan political consideration. They considered the American practice, where judges of the Superior Court of Judicature are removed by impeachment in Congress.
That's right.
They also consider the British process, where they are removed in Parliament.
Okay.
Okay? And they said, no, we don't want to go political. So we will want the test to be the prima facie case being determined by a state organ, the Council of State, in consultation with the President, or the President in consultation with the Council of State. And then in 1969, they said a judicial committee. But now in 1979 and 1992, we've changed the judicial committee into a committee.
Yeah.
That reasoning is what has found its way into the 1969 constitution. So principally, the process is to be insulated against political, partisan political manipulation. That's the first thing.
Okay.
The second thing is simple. We say that, well, the president could have shelved it. Transparency and good governance could not support that.
That's right.
Accusations of incompetence, misbehavior, infirmity of mind cannot be shelved. There will be gross dereliction of duty on the part of the president. And I will never support that idea.
All right.
Okay? Thirdly, I've said, now when they say the NDC is bastardizing the process and is doing that to pack the courts, I said they're not looking at the records.
Politics.
That's politics.
That's politics.
They're not looking at the records. I mean, if you look at the records of the composition of the Supreme Court now, there are only 2 judges who are not appointed by the Nana Addo Dankwa Akufo-Addo. Is the president seeking to dismiss all of them and pack the courts? It cannot happen. So let's let the process through. And like Oliver has said, this is the beginning, the preliminary stages. Everybody, including the president, is keenly aware of the onerous responsibility placed on him. The Council of State is keenly aware. The people that she has told us that Justice Barr said judges are not malleable, what articles of clay or something of the Chief Justice. So is the committees established. They have reputations, they have integrities. They are men of the world. They have been put together to determine whether to go into the matter and ascertain whether the petitioners can prove those tribal issues.
Thank you.
If they are unable, I trust that the committee will do the needful.
That's right.
Thank you very much. Thank you very much. And I need to make this quick. So there is a circular. It's actually an internal sort of memo by the Deputy Judicial Secretary, and it's calling on to registrars of High Court, Court of Appeal, and the Supreme Court. And the subject is assignment of courts and fixing of the dates for newly filed cases and all newly filed applications. And this has been subjected to some interpretation in the public. My information, as I'm receiving from those who must give information about this, is that it is not intended for the acting Chief Justice to, as it were, micromanage any process. There had been an earlier process where if you file an application, for example, you will not be giving a date. Now, they want to give dates so that when you file the application, you know that the application comes on this other date. So if you see Visitor Sefua's process that he has just filed, they have given them a date, a return date, when they will come to the court. And this was part of the process, so that instead of you file no date and later all the confusions that come with it, they've decided that all those cases must have a specific date to them. The Judicial Secretary had actually intended to resign earlier because she wanted to sit in the Court of Appeal where she's a judge. And so it is also not fair for people to say because of this process, she has resigned. I'm informed that she wanted to get off that job so that she can sit in the court and do her job as a judge. So if you have heard that she has resigned, it was something she was seeking long before now. And the deputy has simply been asked to take that position now until someone else gets to occupy it. We'll take a quick break. We'll be right back on Galamsey. You're welcome back. This is Newsfile. It's your most authoritative news analysis platform. And here on Newsfile, we put Ghana first. Francis Nyamiche says it is pure political witch hunt. Mahama and the NDC, right after the 2020 elections, have developed some hatred for persons like the Chief Justice and the Electoral Commissioner and kept drumming their intentions of kicking them out should they win. It's not as if they have erred. Carl Flink says, we Ghanaians, and indeed the majority of Ghanaians, fully support her suspension. Benjamin Owusu says, are we being fair to this woman? I cry for this nation. I'm told she has worked for over 38 years. I'm so sad, Mr. President. We're all AG members, Assemblies of God church members. You cannot eliminate this woman with these flimsy petitions. Ohene Habi says, it's never right for government to focus its attention on the CJ. We have more pressing issues in the country currently: Galamsey, Dumso, rising cost of living, and more. Excellence reigns, says the suspension is in the right direction, and there is nothing wrong with suspending the Chief Justice. There was so much bias in the justice system, and it needs a major reform. OFORI-ATTA says she was too political instead of being independent. None of the purported petitions you have read have any of these lines that she was too political. The women's advocacy government is sacking women from office. And finally, Joe Eric, assuming what Sami Jemfi put out as excerpts of response from the CJ is true, one must ask, where did he get the document from, and who is leaking the document? This is unfortunate incident, and it's marred Professor Azan's petition in 2024. Thank you very much. I've got some of you who have sent messages to me privately. Unfortunately, I'm not going to read any of that. Look for the platform and put the message there. I'll read it from there. Remember, I'm capable of manufacturing messages. All right, so let's go to Godfred Akoto Boateng. Godfred, thank you very much for joining us.
Thank you, Samson. Good morning to you.